wish to make a statement on the report of the Commission of Inquiry on the disposal of shares of BAI Company Mauritius Limited in Britam Holdings Limited, Kenya. The House would recall that in reply to Parliamentary Question B291 on 21st of July 2020, I informed that the report of the Commission of Inquiry on the disposal of shares of BAI Company Mauritius Limited in Britam Holdings Limited, Kenya, was being awaited. I now wish to inform the House that the Commission of Inquiry has submitted its report to the President of the Republic on 2nd July 2021. I received a copy of the report on the same day, and Cabinet has already taken note of the observations and recommendations of the report. As the House is already aware, on 8th April 2017, the President of the Republic had set up a Commission of Inquiry to inquire into the facts and circumstances in which shares which BAI Company Mauritius Limited and its related entities held in Britam Holdings Limited were sold. The Commission of Inquiry was chaired by Mr. Satya Bhushan Gupt, Doma, retired judge of the Supreme Court, and had as assessors Mr. Sattar Haji Abdullah, chartered accountant, and Mr. Imrit Ramtohal, financial analyst and chartered certified accountant. Mr. Speaker, sir, the first meeting of the Commission was held on 18th of May 2017. 25 sittings were held in public and 12 sittings were held in camera. 44 witnesses deposed before the Commission. The Commission, in accordance with its terms of reference, was to inquire and report into 1. Whether the method of disposal of the shares of the BAI Company Limited and related entities in Britam Holdings Limited was in the best financial interests of the seller. 2. The circumstances in which the special administrators, Messrs. Yakub Ramtullah and Rod Chung, did not proceed with the sale of the BAI Company Limited and related entities' shares in Britam Holdings Limited for the sum of 4.3 billion rupees offered by a potential buyer, namely MMI Holdings Limited of South Africa, and instead proceeded to sell the said shares to the existing shareholders, namely Messrs. Peter Munga and other investors for the sum of only 2.4 billion rupees. 3. Whether there was any transaction advisor for the said sale, and to inquire into the role of BDO in the said transaction, and to inquire whether there was any conflict of interest in relation to BDO's involvement. 4. Whether all proceeds from the said transaction have been received to date, including dividend, if any, prior to the said sale. 5. Whether funds have been transferred otherwise than into the account of the seller, and the amounts received, if any, into any third-party account, the currency in which it was so received, and any amounts retained as fees or commissions by or paid to other parties. 6. Whether in relation to the above transaction there has been any fraud, malpractice, corruption, undue influence, or other misdeeds by any person involved in negotiating and finalizing the sale of said shares, and whether any financial prejudice has therefore been caused to any person in Mauritius. 7. Whether Kenyan shilling was the underlying currency of the transaction, and why the Kenyan shilling was preferred to US dollars. And report on any matter ancillary to the terms of reference, and to establish responsibility, both criminal and civil, of all persons, entities, companies involved in the said transaction, and make recommendations thereon. Mr. Speaker, sir, based on the depositions of witnesses and documents scrutinized, the Commission has addressed all the issues included in the terms of reference and has come up with a number of conclusions, some of which I wish to highlight. At the very outset, the Commission has, at paragraph 264, highlighted that in the BAI Brahma banking saga, both KPMG and BDO, as auditors and accountants, failed in their professional duty and responsibility in public interest to bring to the attention of the financial institutions concerned and the investing public the precarious financial situation of the BI Group. They had duly reported the state of affairs to the Company Audit Committee, but they failed to advise the public as they should have done through their report. Had they done so, the public would have exercised due caution. The Commission has also dwelt on the role and responsibilities of auditors and regulators, and have made pertinent remarks at paragraphs 262 to 276. In fact, at paragraph 276, the Commission was of the view that the collapse of the BI Group might have been prevented had KPMG and BDO acted responsibly and qualified the audit report of the BI Group. With regard to whether the transaction was in the best interest of the seller, the Commission concluded that, I quote, A. There was no formal method used for the disposal of the shares of the BI Company Limited and related entities in Britam Holdings Limited. B. It was by one-to-one discussion taking place behind closed doors where Cabinet, the Financial Services Commission, and National Property Fund Limited board were all kept in the dark. C. Lack of method was coupled with lack of record, lack of science, and lack of professionalism of those who were involved. D. The result of that lack of method, lack of record, lack of science, and lack of professionalism has been that it has caused tangible prejudice to the NPFL, which as per the law should have been the seller. E. The NPFL, as the shareholder, was debarred from exercising any key ownership function in the exercise of its ownership rights in the sale of the shares. So was the government as the sole shareholder. F. Shareholders, if prejudiced in their rights, have a cause of action against the authors. Unquote. Mr. Speaker, sir, concerning the underselling of the Britam shares at 2.4 billion Mauritian rupees, The Commission remarked that had the undertaking been transferred to NPFL, as had been decided by Cabinet and which was known to ex-Minister Bada, the Special Administrator and BDO, the NPFL would have gone through the procedures of the sale and exercise its key ownership rights as per established procedure. The shortfall of 1.9 billion Mauritian rupees was obviously due to the lack of proper methodology and evaluation, the absence of proper negotiation, and the non-existence of a transaction advisor and legal oversight. Regarding the role of some of the main protagonists in the disposal of the Britam shares, the Commission had the following to say, I quote, "The facts reveal that BDO had a major role to play in the transaction, a role which was unethical, unprofessional, and irregular, but that the ex-minister had something to do with it," unquote. Mr. Speaker, sir, on the same note, the Commission has also made a number of pertinent observations on the conduct of the public affairs. I wish to stress on the following, which I quote. Aside the fact that the matter of sale was never brought to Cabinet, the decision that the undertaking should be transferred to NPFL was simply ignored. The proposal for the creation of NPFL originated in the report submitted by BDO and Company Limited to the FSC, recommending strategic measures to protect the value of underlying assets of BAI. At one of the strategic measures, that is paragraph 9.1 of the report, it has been recommended that the government needs to set up a NPFL as a wholly owned subsidiary of NICL. The decision to entrust BDO and Company Limited to produce the report was taken reportedly in a meeting chaired by ex-Minister Bada in his office in the presence of other ministers and high officials of FSC, advisors of the minister, and BDO and Company Limited as well. This is not the way public affairs are run. On matters of appointment of experts, ministers do not gather condescending ministers and officials to choose a contractor in the manner of a roving mini-cabinet. The manner in which BDO and Company Limited was appointed to prepare the strategic measures in the aftermath of the BAI collapse leaves a lot to be desired, unquote. On the question as to whether there had been any fraud, malpractice, corruption, undue influence, or misdeeds, the Commission's reply was, I quote, that the acts and doings are suggestive of all those offences and or breaches incurring criminal and civil liability as the case may be, unquote. Mr. Speaker, sir, the Commission has also highlighted that the facts elicited in this inquiry reveal the possible commission of criminal offences by a certain number of persons. In this respect, it has recommended that criminal investigation be carried out by relevant authorities for possible offences relating to forgery or making use of a forged document under the Criminal Code, and or giving false evidence in the proceedings before the Commission. The names of persons, entities, and companies are mentioned at page 347 of the report, and I propose to refer the matter to police for inquiry. Furthermore, the Commission has indicated that there might be possible offences relating to breach of sections 109 and 215 of the Insolvency Act. With regard to whether all proceeds from sale transaction have been received to date by NPFL, including dividend, if any, prior to the said sale, the Commission came to the conclusion that NPFL had been unfairly deprived of an amount of approximately 43 million rupees, representing dividend in 2015. Mr. Speaker, sir, the Attorney General's Office has also been consulted to determine whether civil proceedings could be initiated against the persons and institutions concerned who may have incurred civil liability by their acts and doings. Mr. Speaker, sir, let me conclude by informing the House that I am tabling a copy of the report of the Commission which will be made public. The Commission has made several other recommendations and same are being carefully examined and their implications.